Have you ever wondered what happens when someone tries to evade the law and escape from the execution of warrants against them in India? This is where Section 82 of CrPC steps in. This section of the Criminal Procedure Code is a mechanism designed to bring those who run from justice back to the court. It comes into play when a court has reason to believe that a person has absconded or concealed themselves to evade the execution of warrants. The court can form this opinion either on its own, based on the material on record, or on the evidence presented by the prosecution. Once the court's gears of belief are set in motion, it proceeds to issue a written proclamation. This is an order for the accused to appear at a specific place and time, giving them no less than 30 days from the date of publishing the proclamation. But remember, Section 82 of CrPC is not used to punish the accused, but is designed to compel them to appear before the court. Now you might be wondering, how does this proclamation work? Let's explore the procedure. First, it's key to understand that a proclamation under Section 82 of CrPC is a formal notice from the court to an individual who has, in all likelihood, absconded or concealed themselves to evade the execution of warrants. This is not a punishment but a legal maneuver to compel the person to appear before the court. The process begins with a written proclamation. The court orders the accused to appear at a specified place and time, which must be at least 30 days from the date of the proclamation's publishing. This ensures the accused has ample time to respond. Now, how is this proclamation published? The law provides 3 primary means. First, the proclamation may be read aloud in a conspicuous place in the town or village where the accused ordinarily resides. This could be a public square, a market, or any place where it would likely catch attention. Secondly, the proclamation can be affixed at a conspicuous part of the house where the accused person usually lives. It's like pinning a notice on the front door. Alternatively, it can also be affixed in a noticeable part of the town or village, ensuring maximum visibility. Lastly, the proclamation can be circulated through a daily newspaper that is widely read in the place where the person usually resides. This method ensures that the news reaches not only the accused, but also the larger community, increasing the chances of compliance. So the court isn't just issuing a proclamation out of the blue, there's a thoughtful process behind it. The court forms its opinion from the material on record or based on the evidence presented by the prosecution. The issuing of the proclamation cannot be done arbitrarily. There must be reasons recorded by the court to substantiate the order. The process to issue a proclamation is not arbitrary. The court has to record reasons to substantify the order. So, what happens when the accused does not respond to the proclamation? They may be declared as a proclaimed offender. Let's delve into this term a bit more. A proclaimed offender is a person who, after being accused of serious offences under the Indian Penal Code of 1860, fails to appear as required by the proclamation. At this point, the court can declare the accused a proclaimed offender, but not before conducting an inquiry into the matter. It is essential to remember that this title is not given lightly and is the result of a person intentionally evading the law. Now let's discuss the repercussions for a proclaimed offender. For starters, a police officer can arrest such an individual without any warrant. Yes, you heard that right. No warrant is needed. Even a private person can arrest a proclaimed offender and present them to the nearest police station. This provision underscores the seriousness of being declared a proclaimed offender. The title of proclaimed offender comes with severe legal consequences. A person bearing this title can face imprisonment for a term that could extend to 7 years. Additionally, they may also be liable to pay a fine. However, it's important to note that the title of proclaimed offender is not permanent. It ceases to exist as soon as the person is arrested or otherwise becomes capable of being presented before the court. In essence, being declared a proclaimed offender is a significant legal development in a person's case. It is a clear message from the court that evading the law will not be tolerated. It is the court's way of compelling the accused to face the charges against them, ensuring that justice is served. So remember, if someone is declared a proclaimed offender, they are in a serious legal predicament. It is a situation that comes with grave consequences and is not to be taken lightly. Being declared a proclaimed offender can lead to serious legal consequences, including imprisonment. Let's clarify the difference between a proclamation and a proclaimed offender. The distinction might seem subtle at first glance, but it holds significant legal implications. A proclamation, as outlined under Section 82 of the Criminal Procedure Code, is essentially a public notice issued by the court. It's an instrument used when the court has reason to believe that a person, against whom warrants have been issued, has concealed themselves or absconded to evade their execution. The court orders the accused to appear at a specified place and time, typically no less than 30 days from the date of the proclamation's publication. It's crucial to note that the objective of issuing a proclamation is not to punish the accused, rather it is to compel them to appear before the court. Now let's talk about a proclaimed offender. This title is conferred upon a person who not only has a proclamation issued against them, but also has committed a serious offense as per the Indian Penal Code of 1860. It's not a title given lightly. The court conducts an inquiry to confirm that the person has intentionally been in hiding to evade the execution of warrants. Once declared a proclaimed offender, the individual opens themselves up to penal liabilities and other disqualifications. A police officer can arrest a proclaimed offender without a warrant, and even a private person can arrest such an offender and present them to the nearest police station. The title of a proclaimed offender ceases to exist as soon as the person is arrested or otherwise becomes capable of being presented before the court. However, they can be liable for a term of imprisonment that may extend up to 7 years in addition to fines in tandem with such punishment. Therefore, while a proclamation is simply a public notice, being declared a proclaimed offender has significant legal implications.